I am Stephanie Hanzl, the president of the Liability Chapter of PAHCOM. On with me is Brenda Foose, vice president. Tonight, we have the pleasure of having two attorneys from Norris McLaughlin. They're going to be presenting on liability issues in the time of COVID-19. First, we have Peter Lehr. He's a member at law firm Norris McLaughlin. He focuses his practice on healthcare transactional and regulatory matters, real estate and land use law, including zoning and subdivision applications and commercial lending. Some housekeeping slides. CEUs, it is only CMM. I promise we will get some HIT CMPP credits in 2021 for those who need those. And again, it'll be recorded and available as a YouTube video in the PAHCOM website library. And we are doing what we love to do, is share our knowledge. So let me start with Peter.
Hi, thank you for
You're very welcome.
Inviting us to give this presentation today. And again, like I'm sure many of you, I'm for obvious reasons. In addition to which, I think the Buca di Beppo restaurant would have been one of the more interesting locales that I would have been asked to give a presentation. I really enjoy the restaurant. I'm sorry to hear. I think I heard earlier on that at least on Great Street might close, hopefully temporarily.
Yeah, I did hear that today too.
Yeah, so it's very very interesting times that we're involved in. So anyway, I am an attorney with the law firm of Norris McLaughlin. We have offices in New York City, as well as Bridgewater, New Jersey, and also Pennsylvania in Allentown. I'm one of the healthcare practice group attorneys with our firm. I have spoken to this organization in the past, so hopefully some of you may remember me. If not, it's good to be here again. I thank you for the opportunity. Just so you're aware, I think it was touched on my background. I do have experience, 20 plus years experience in healthcare transactional work, from advising physician, both single and multi-specialty practices, and on a variety of issues ranging from contractual to reimbursement to regulatory. And obviously, since February, we've been advising clients with respect to issues associated with the coronavirus. And so with that, I think I'll start the presentation by just letting you know that the topics that we're going to cover today are liability issues. There's certainly a host of other issues that are associated with the coronavirus. We're going to touch on a couple, and let me see if I can first see how do I work these slides. Oh, next. Sorry. So given the audience, I'm sure most of you were thinking that from a office standpoint, running anything from a healthcare facility to a single and multi-specialty physician practice to any other type of healthcare provider, that it wasn't easy before February, and certainly since February there's been a whole additional set of challenges. I always think of healthcare as being, number one, a provider of services, medical healthcare services, but also a business, and both of them present their own challenges. Now it's being a provider of healthcare service during a global pandemic, and also being a business in a time when many businesses are ceasing to operate. My hope is that in giving this presentation to you, that will assist you in dealing with some of the challenges, hopefully understanding the law, liability. There is some good news on the liability front that I'll discuss later on in the presentation. But just speaking frankly, in the spring, my expectation was that the effect or the transmission rate would sort of be, hopefully a curve would be cut off so that it wasn't that great in the spring, that it would go down in the summer, and that we would have a mild increase in the fall. And that's certainly not what is happening now. What we're finding, obviously, is that the rate of infection has taken off in the last month and appears to be, from most accounts, higher than it was back in the spring. And as a result, you see healthcare facilities, hospitals dealing with increased admissions, and that's obviously not what we want to see. But that being said, we are dealing with unprecedented times. I'd like to start off by talking about some of the trends that we've seen in healthcare business pre the pandemic. And, you know, number one, we're dealing with, from a provider standpoint, increased operational costs. And I don't think I have to tell you that the items such as overhead, including health insurance for employees, the cost of supplies, the inflation in the medical field in general, those costs were increasing. And so that was a trend that was happening before we got into coronavirus, coupled with also, I think, generally speaking, declining reimbursement across third-party payers, Medicare. Those rates of reimbursement were declining, and we're a couple years, I say couple, probably 5, 6, 7 years out from what really had been a turn to try to get to value-based reimbursement, and the awarding of primary care physicians or specialties. But I don't think that those initiatives really have resulted, and you know better than I, in really an increased reimbursement from health plans, third-party payers. In addition to which, you have an aging provider population. By that I mean you have physicians who are fewer in number, and the median age of which is continuing to get older. What that has resulted in is really the rise of the mid-level providers. You've seen the physician assistants, the nurse practitioners. These are professions that are becoming more and more prevalent in office settings. So, but again, grappling with the fact that to some extent those can be independent, but they typically are part and supervised by licensed physicians. The other thing that you've seen prior to COVID is health system alignment. And by that I mean you have seen health systems growing both in revenue as well as scope and reach, and a decrease in independent or small group models that would be single specialty and multi-specialty physicians. So as a result of that, you have a lot of these independent practices seeking to partner with, through various means, these health systems, which leads me to the next part, which is the consolidation. And by consolidation, we mean that independent practices are becoming part of health systems. We've had super groups, not so much in this area, but in other areas, metropolitan areas. So that's, you know, those are the trends that we saw pre the coronavirus. So what are we seeing then, you know, since February, in addition to a great deal of, you know, uncertainty, things that from an office standpoint that we're going to talk about. But pretty immediately we saw in the spring, I believe starting in March, was the CARES Act Provider Relief Fund Many of you, I think, are aware of what that is and what it stands for. Many of you may have made requests to get disbursements as part of that. So you are aware, and many of you are. Provider Relief Fund was really a $175 billion federal government subsidy program. It really partnered with the Payroll Protection Act to help healthcare providers, including single multi-specialty practices, get funds to help combat COVID, and recognize that the financial strains on these healthcare providers were unprecedented. Now, these relief funds were released in several rounds, and I believe we're on round 3 starting in October. But there are a couple of qualifications, and again, I don't want this to be a CARES Act presentation because you're already aware of it, and you probably are already using it. But there was a change recently, which I'll talk about. But if you billed Medicare or Medicaid in 2019, as well as met certain other criteria, you could qualify to get disbursements from this relief fund, as other businesses have gotten from the Payroll Protection Act. And so the use of those funds was limited to reimburse providers for healthcare-related expenses or lost revenues attributable to the coronavirus. And that's also qualifying that those costs were not reimbursed by other sources. And since March, what we've seen is a lot of providers have informed the federal government that limits the use of those funds, and providers continue to struggle with trying to address other costs. So as a result of that input from the provider community, the federal government in October, as part of round 3, clarified the use of those funds. So in case you are not aware of that clarification, once you use these provider relief funds for healthcare-related expenses or lost revenues attributed to COVID, any remaining distributions can cover lost revenue, which is measured, really any lost revenue. It doesn't have to be related to COVID. And it's measured as a negative change in year-on-year actual revenue from patient care-related sources. So again, you're not limiting the use of those funds to simply COVID. You can actually use them to reimburse or make up for lost revenue, which, as I define, is year-on-year negative change from actual revenue for patient care. So that is a very brief summary of the Provider Relief Fund. It continues to be there. It continues to make disbursements. But what I think is somewhat concerning is there was an initial allotment, and I'm going to touch on some of the other financial related issues that some of the higher providers are dealing with. But again, we're talking here about you had an infusion of revenue, and now you're dealing with potentially the end of the tunnel. There's no light there, but there's an end of the tunnel, at least not yet, from the CARES Act, the Provider Relief Fund. So let me also talk about something which I'm sure that you've also had dealings with, which is the rise of telehealth. This is a topic that David is going to touch on later in terms of how rules have been changed to increase the availability of telehealth services across provider specialties. But I think you've recognized that, with these, ability with people being limited to home and providers not or hoping to limit exposure, that telehealth is being used. I can tell you that when this pandemic started, one of the things that I was able to do through our local health system, Lehigh Valley Health Network, is that they actually had a My LVHN app that allowed you to register and I went through, in the event that I would become symptomatic with COVID symptoms, there were, through that app, the ability to be screened virtually by a qualified healthcare provider who would then make the determination as to whether or not testing would occur. So anyway, I'm sure I'm not telling you anything that you don't already know, but that's a trend that we do not anticipate is going to abate with hopefully the quick resolution of the coronavirus. So it's going to be interesting when we get to that portion of our presentation to talk about telehealth. Elective procedures. For those of you who are managed offices in certain specialties, I'm sure you've very much realized very quickly that elective procedures were down. And what I've seen is 30 to 55% down across the country during the first wave. Now, and again, I'm basing it on information that I've seen, really you're looking at elective procedures being about 82% of what they were pre-pandemic. Now that's prior to the second wave, which I think really started about a month ago, and we're kind of dealing with that. But the bottom line here is that people are foregoing elective procedures. And some of the considerations that we need to start thinking about as part of this is what's going to happen once this coronavirus subsides. Is that elective procedure? Are you going to have a bunch of people now rushing to get elective procedures? Hopefully that's the case. Or is this more permanent? And I don't think there's really an answer to that yet. And I think it depends on a lot of factors. Obviously, people's financial situation and whether they're covered by health insurance and what the status of that is always dictates whether somebody's going to have an elective procedure or not. But that's something that the healthcare industry as a whole is trying to come to terms with. Is this going to be a sea change, or is it going to be, a temporary stoppage of those types of procedures? Employment attrition. Again, I've talked to professionals, and they don't even have to be healthcare professionals. And there's been downsizing, but there's also been people who are unable to work as a result of situations that are going on in the home. And that can affect different specialties within the healthcare field. So again, people are, the whole purpose of some of these legislation rules that we're going to talk about is to increase the number of healthcare providers. But I'm sure you've seen that people are not as willing to work as long or at the hours that they're working in these healthcare spaces. So that's another trend. Again, what's going to happen when coronavirus abates? Is that going to uptick? I think at least in the short term, it will, based on what I've read. But again, people are going to be, I'm sure as you are, exhausted with having to go through that, and that maybe long-term might curtail the available people who would be in the healthcare space. Consolidation will absolutely continue as it has pre-pandemic, meaning there are going to be fewer and fewer independent practices and larger and larger providers of healthcare services. Again, I think the only thing you can say is coronavirus really is increasing something that had already been seen for the factors that we talked about before. And then finally, and unfortunately, insolvency and bankruptcy in the healthcare sector. It's interesting to note that 2019 had the highest number of bankruptcy filings by healthcare providers. That was 2019, before the coronavirus pandemic. I've looked at information such as provided by Kaufman Hall, and hospital margins, and we're talking about nationwide based on the Kaufman Hall survey. In the second half of 2020, the margins were negative 7%. That Kaufman Hall is projecting that more than half of those hospitals will have negative margins in the fourth quarter of 2020. So you've got consecutive, in a lot of these systems, consecutive quarters of negative margins. Again, we're talking nationwide on average. So you're talking about, and we've seen it in places like the city of Philadelphia, hospitals and health systems, community hospitals struggling with what is now occurring and being buoyed by the Provider Relief Fund. But what does that mean once we're through here? What is that going to look like? And while consolidation can occur, there are going to be an increased number of insolvencies, bankruptcy proceedings, and workouts. So again, these are some of the trends that we're seeing post-COVID. I want to take a moment and just talk about, sort of give you an overview of what we're going to cover in the remaining time that we have. I'm going to talk about the risk of liability from COVID-19 and some of the mitigation efforts that you can use in your offices to reduce the risk of liability. As I said, there are some silver linings in terms of protection, but we have some strategies that I can share with you now. Patient relationships, how are the patient relationships going to change? And you know better than I. This is not something where I'm going to lecture you on how that's changed, but I'm going to share some things that we're seeing. Employee relationships too, as we talked about. Employees are having their own challenges in providing services. Provider relationships, relationships with physicians, relationships with referring sources or sources of referrals. How's that changing? Vendor and landlord relationships, and this is really getting to more of the business end of the healthcare provision. And what's that going to be involved? And then finally, we're going to talk about telehealth, some of the initiatives there, and I think David is also going to touch on what's going to happen with the rollout of the the COVID-19 vaccine. What I also want to just take a moment and just mention here, I have a slide for you even, that I don't know if we're going to be able to do it. Hopefully we can. But my hope is that rather than have us kind of talk at you and then save everything to the end, that maybe at the end of each segment, we could pause and receive input. And I really think that would be helpful, particularly given who we have on and the numbers that we're talking about. Maybe we can pause and I can say if anyone wants to be recognized and there's a means to do it. I have to confess, I'm not technologically savvy enough to know how to do it on this platform, but I'm sure that we can figure that out. But I do think it's really important for us to be able to talk about the risk you're seeing and any risk management strategies that you're employing.
Yeah, thank you, Peter. Please enter your comments, questions in the chat, and Brenda and I will monitor it and see if anybody has any questions for you before David proceeds or starts.
Yeah, and I think I may pause throughout my presentation just to get some input if that works. If it doesn't work, we'll try something else.
All right. Yeah, I'm just gonna take my video off so everybody can read the slides because I think.
We cover the slides partially.
Yeah, our pictures will be, are covering the slides. I'm just going to turn my video off, but my microphone is still on.
Okay. That's helpful. And if for some reason you can't see it, I'll be reading through them. So let's talk about risk of liability. There are immediate risks that arose in February. Obviously, people were recognizing that what was happening in Wuhan was quickly becoming a pandemic, and that didn't filter through the system from government agencies to businesses. You really recognized it very quickly, I'm sure. Some of you dealt with issues or challenges related to scheduling. Obviously, patients were canceling. Offices were scheduling. Offices had to close periodically to implement mitigation measures. I will tell you that locally, I think it was handled very well with the providers that I'm familiar with in terms of working through that. scheduling part. You also had risks immediately to clinical and non-clinical personnel. You're dealing with a respiratory virus, so people obviously, despite, whatever happened with the government, were recognizing that personal protection equipment was going to become essential on all fronts, and therefore steps needed to be taken to protect the clinical and non-clinical personnel. The revenue and expenses, and again, the expense portion didn't go down, and it certainly went up. But the revenue was drastically affected, particularly with specialties when you're dealing with orthopedics and other elective procedures, which tend to be the higher reimbursed procedures, were being canceled. So you had a loss of revenue and an increase in expenses. And again, it was not gradual, I assume. That was really immediate on the fronts that you're dealing with. Patients, risk to patients. This was obviously, people were being ordered to remain at home, encouraged to work remotely, really isolated. And that presented its own set of risks. But it also, patients need to have health care. So they were going into healthcare settings, which again presented challenges. Building operations, and I'll touch on this a little bit later on, but you had some people own their buildings, some people rent space or lease space. And a lot of landlords were trying to figure out how to deal with this situation, recognizing that they were, in certain respects, responsible for certain things within the lease space, and may not be able to provide that. So they were providing notices to tenants. Tenants were also providing notices to landlord that they would not be operating in certain spaces, downsizing, and things such as that. We'll talk about that a little later on in terms of kind of mitigation strategies, but that again was sort of immediate risk. And the landlords weren't saying it's fine if you shut down your office and don't pay rent for several months. Typically they were not. So that's another immediate risk. Online options, again, people were already getting acclimated to telehealth, but this certainly yanked it forward. And so people were dealing with telehealth, but also communicating basically with patients across online and in email, having them complete surveys before they came in, as a means to try to limit the time in which they're actually in the patient space. So that's immediate liability. Let's talk about lagging liability. There's a recognition in the legal field that COVID-19 would present litigation, and that the litigation would likely start off slowly and rise quickly. Courts themselves were entering emergency orders, which had the effect of limiting the public proceedings, whether that be civil or criminal trials. That has resulted and continues to result in a backlog of how that's being handled in litigation. And again, that's why we talk about lagging liability. It's not like the litigations won't go forward, but they are to some degree delayed. Contractual out or hold clauses. We talk about that. We talk about the fact that certain contracts have provisions within them to deal with it, but what we found is that the assumption that they would be covered under what's called a force majeure or an act of God clause wasn't necessarily the case. And so depending on which side you were of the contract, that people were providing notices. Ideally, they were entering into discussions to modify or amend contracts, but that obviously doesn't happen in every case. So you had this, are we out of the contract due to an act of God? Are we able to modify the contract based on certain items? These are things that are sort of the lagging liability. Insurance carriers were obviously starting to put on notice of potential claims. And then the last point there is the growing number of claims filed and lawsuits filed. So that's immediate lagging liabilities that we're identifying. So I'm going to share some data with you, and I do want to preface this by saying, you see the source that I got the information on. These are, I believe, Pennsylvania-related numbers that we're talking about as of the end of November. And please note that this is a general because there is no uniform tracking of claims that involve or lawsuits that involve COVID. You'll see here that this company was able to track 287 COVID-19 related lawsuits. The vast majority, 156, are insurance-related claims. Again, not surprisingly, but also included in there are certain other ones, contract disputes, as we talked about, labor and employment, people alleging that, for example, their workspace was unsafe. So you had potential employment-related claims arising from that, and then obviously health and medical as well. Obviously, more lawsuits are going to start coming in those fields. I think this slide hopefully gives you a sense of kind of where these are initially. And again, just looking at the numbers as a lawyer, you are a little surprised that there were only 25 or 34, but I can tell you that that's going to grow. And we'll talk about more about that. There are also defenses to be raised in connection with these lawsuits, and I want to touch on those as part of sort of the mitigation strategies that we're recommending. But let me talk to you about emerging theories of liability related to COVID. Why are healthcare providers allegedly responsible for personal injury, wrongful death, or other torts, meaning lawsuits related to COVID-19? Well, what we're seeing here are, claims that allege negligence. Negligence is a fairly common term. I'm sure you've heard of it before, but there's a standard that you needed to meet. You didn't meet it, therefore you were negligent. Therefore, I suffered damages. Therefore, I am filing a lawsuit against you. Gross negligence. I'll touch on this, weighing how much we want to get into it in this presentation, but the term gross negligence from a legal perspective in Pennsylvania is one that has a strange history, because I don't know that you would really be able to define it as you can in other states. But obviously the name suggests that it goes above just mere negligence to gross negligence, where you are somewhat wanton in your disregard of the standard. I think that's generally true. But as I said before, in Pennsylvania at least, it's something that you really would not be able to really give it a clear definition from a legal perspective, based on how the courts have interpreted that. Medical malpractice, obviously, and in that I include professional liability actions that are being lodged against long-term care and nursing home facilities predominantly. And then violations of state law or statutory violations. Oftentimes, lawyers, plaintiffs' attorneys are citing violations of laws as evidence that you fail to meet the standard of care. In the normal stages, this was something where there were a series of laws, for example, that dealt with infection control in facilities. Well, with COVID, we're dealing with a whole new ballgame, and so you can certainly cite to violations of those standards, but what does that mean in terms of global pandemic? I will tell you that Pennsylvania is among the top states in terms of personal injury suits that have personal injury and wrongful death suits that have been filed against particularly nursing facilities. Please note also among those are New Jersey and New York. So the Northeast region would typically be seeing that. I expect in other high cases where the infection rate in those facilities has resulted in deaths that also to increase. So what are we seeing in terms of common threads here? When you look at these complaints, you see, allegations of failure to act or failure to administer, employ, or provide countermeasures to prevent entry and to stop spread. Now, we're dealing with physician offices, other smaller facility offices. When I say we, I think we're talking about the groups that the people that are participating in this presentation as office managers. But it's interesting to note that if somebody were to allege something there, and please note, and we'll talk about this, how would they know where they got it? Well, contact tracing, there are means by which you could determine where the source of the infection was. So, if it is determined to be in a specific setting or location, then were countermeasures taken to prevent both the entry and the stop of the spread? Failure to observe guidance from health officials, federal, state. There are obviously, as you are well aware, the Center for Disease Control has issued guidance or guidelines to healthcare facilities. And so have you followed that? If you have not, then is that sort of an actionable part of a theory of action against you? Failure to create a safe patient environment, I think, kind of speaks for itself. Failure to employ staff. Again, we're talking about a time in which you are experiencing staff shortages or people having to work different hours. But that's another theory that we've kind of seen in some of these complaints. Failure to have or use personal protection equipment is another one. This particularly seems to be relevant in cases of employer-related litigation, where somebody who is employed alleges that an unsafe workplace was created as a result of failure to provide them with PPE. Failure to notify patient of the risk of infection, and we're going to talk about consent forms and things that you may want to do to try to mitigate that type of a risk. And then, as you can see in the slide, almost surprisingly, failure to administer a vaccine, even though a vaccine is not, in fact, approved through any of the mechanisms, at least in the United States, that are there. So those are some of the emerging theories that we're seeing here. Let's talk about the different declarations that have occurred. There was early recognition, as I said before, that the healthcare sector would be heavily tasked with responding to the pandemic, and resources would need to be deployed and steps taken. And what ultimately came out of this was basically a disaster declaration for the country, as we've seen in various spots where you have a natural disaster. There's a disaster emergency declared. This one was basically throughout the entire country as a result of the possibility of infection from COVID-19. So on a federal level, you had the president declaring a national emergency. The Department of Health and Human Services declared a public health emergency. The state governor here in Pennsylvania declared a disaster emergency. And then many local municipalities have declared a local disaster emergency. So there's no doubt that across federal, state, and local, that there have been these disaster recognitions, and that plays into some of the defenses that can be raised, and which I'll talk about in a moment. So let's talk about the Pennsylvania governor and Department of Health. There were a series of declarations, orders, and guidance. I don't think I need to go through all of them because I think some of them are familiar with you. Obviously, initially, the wearing of face masks and social distancing was one of the mitigation efforts that was ordered by the governor. Let's talk, though, about some of the other ones that sort of arose in the spring here. Telemedicine. There was a temporary suspension of requirements for out-of-state licensees. So again, telemedicine across state lines was encouraged. There was an expedited, for temporary licenses to out-of-state practitioners. Talk about physicians who may be licensed in another jurisdiction of having temporary license issued on an expedited basis. I use the term loosening of restrictions on practice of physicians. And what I generally mean by that in terms of what was part of that order was that they wanted to make clear that physicians should not be worrying about the more sort of business related restrictions on the practice of medicine that you'll see that they've actually ordered that to be loosened. And again, that doesn't mean that you couldn't be held responsible for those, but the idea that those would really be as enforced as they were in normal times is not the case. The temporary suspension of expiring nursing license also was part of that. Going through there, the loosening on the scope of practices of physician assistants and nurse practitioners, again, to try to encourage these mid-level providers to become more active in the healthcare workplace. The loosening of physical therapy, occupational therapy, speech therapy, professional supervision, so they're allowed to practice more independently. Medical students to be used in a limited manner in a hospital setting. And then May 7th, we had an order that granted immunity to healthcare professionals. This was also followed up by, most recently on November 27th, 2020, an updated order requiring universal face coverings, which I'm sure you heard about, but that also touched on briefly liability issues. So let's talk about that May 7th executive order. And I think it's important, this is where we get to some of the silver linings in this, in terms of, not that there's any silver lining in the coronavirus epidemic, but in terms of liability. This executive order granted immunity to certain physicians, nurses, and other providers relating to care of patients with COVID-19. The basis for that immunity, and we're talking about immunity from civil liability, meaning under this executive order, these people would not be subject to lawsuits for provisions relating to emergency services activities. And I've quoted the executive order, as you see, shall not be civilly liable for negligently causing the death of or injury to or damage to property of any person. The exception to that is if it's as a result of willful misconduct or gross negligence, that term that we talked about before that in Pennsylvania hasn't really been fully defined by the courts. And the limit of that civil liability is for the duration of the emergency declaration. So I think the takeaway from this is that the governor has recognized that for those frontline workers who are doing this care, that they are not to be held for negligence for civil liability for personal injury. Now, it really was intended to remove obstacles to care for those with COVID-19, applies to licensed professionals, and includes care rendered by telehealth. So you don't have to necessarily be there to enjoy that shield, if you will, from liability. It would apply via telehealth. The problem was that it did not apply to certain facilities, which would include nursing homes. And also with this, to my knowledge, it has not been adjudicated by a court, the scope of that shield. And that's a theme that we're going to hear throughout this. Now, I'm going to spill the beans here a little bit with the next series of slides. As a result of that executive order, the Pennsylvania legislature, like other states, thought that in order to expand the scope of that shield, that they would pass legislation. And I say spill the beans because the slide presentation that I'm about to give you on this legislation does not take into account events that happened in the last several days, and I'll talk about that. But basically, they recognize the limitations of the executive order. They were lobbied by interest groups. In September, they initiated proposed legislation known as House Bill 1737, which was proposed legislation to extend the liability shield related to COVID-19. So if that passed, Pennsylvania would join 28 other states that have enacted immunity laws that also include New Jersey and New York. In addition to which, federal law, and we'll talk about it, also affords its own immunity from liability. And so we'll touch on House Bill 1737. It narrowly passed the Pennsylvania House and Senate, predominantly based on Republican votes. And again, I'm going to touch on it briefly, but the purpose of the House bill would be afford immunity from civil liabilities or damages for personal injury arising out of treatment or testing for COVID-19 to patients who have been exposed to or whom a covered provider reasonably believes may have been exposed to COVID-19. Now, that immunity lasts for the duration of the disaster declaration, but it would be considered quite broad. You're talking about individual healthcare practitioners, doctors, nurses, mid-levels. You're also talking now about healthcare facilities, hospitals, and nursing homes. Other healthcare providers would include clinical laboratories, and then there's a series of others who I've listed there, including those who manufacture and distribute PPE. It's important also to recognize that this includes claims based on vicarious liability, and sometimes that has to do with the employment context. Vicarious liability means if somebody other than yourself does it, it's actually able to be attributable back to you. So it's a way to be a broad shield of immunity for those healthcare workers. And again, under the House bill, immunity so long as good faith efforts to comply with public health guidelines, including state and federal orders related to COVID-19. It would not apply if plaintiff can establish by clear and convincing evidence that the provider acted grossly negligent, recklessly, or intentionally. And it also protects providers against shortages of PPE and provision of patient care in excess of normal capacity as a result of a need to test for or treat COVID-19. So if somebody was indicating that there was a lawsuit based on provision of patient care in times where you have the excess capacity, those would also be protected. So here's where I have to correct what appears on the first bullet point in this slide. And I apologize, when I prepared this slide, going back 7 or 10 days ago, I didn't know the ultimate outcome, but with the passage, I was cautiously optimistic on behalf of my clients. But unfortunately, that first bullet point is incorrect. It was not signed into law. In fact, it was vetoed by Governor Wolf. So we have to recognize that what I've just discussed with you is not law. I have here parts of what the November 27th order from Governor Wolf said, but basically it limited immunity to some degree. It expanded it from the original order to deal with businesses, government employees, and a limited number of others, including local health departments, except in cases of willful misconduct, gross negligence, recklessness, or bad faith. But all of this is to say that the only thing now, at least at a state level, that's protecting healthcare practitioners is that original order, which has yet to be kind of vetted by the courts. What I do anticipate fairly quickly, but maybe not the balance of 2020, is for the state legislature, when it comes in 2021, to take up again the issue of civil liability. And I would expect that this House bill will present the framework. Not surprisingly, that there was a big pushback when you granted general immunity from various interest groups, including trial lawyers, interest groups, people who would bring actions on behalf of, for example, people who were in nursing homes who passed away. They did not want to be generally barred from bringing suit. So this is the struggle that's going on. This is a development that happened very recently. And again, I expect that state law and Pennsylvania to join the rest of the states in enacting new legislation. But unfortunately, I was hopeful, but by the time I had to give this to you, that legislation was in fact vetoed. Now let's turn from state law to the federal law, and that's the PrEP Act. This is a federal law that was passed in response to the COVID epidemic. You can see what PrEP stands for there. It was passed in March, and it limits liability except for willful misconduct of healthcare providers for any claim under federal or state law for damages caused by or arising out of the use of covered countermeasures COVID-19. And it creates a rebuttable presumption that the administration or use of a covered countermeasure shall have been for the disease which the public health emergency was declared, and therefore the plaintiff has the burden of proving the PrEP Act shield of liability against liability doesn't apply. Now, what has happened since that was passed in March is that a series of litigations have started to pop up in terms of how much of the shield really is that. And for example, a New Jersey federal court ruled that a failure to act, failure to administer, employ, or provide countermeasures doesn't fall within the PrEP Act. Now, that particular decision is on appeal, but you can understand that if this deals with, if you employ a countermeasure, you're not going to be held liable for it. But what happens if you don't apply a countermeasure? The courts seem to have construed that shield very narrowly. In addition, federal courts have ruled that there's no preemption. That means that versus passes federal law doesn't mean that these can only be raised in federal court. They can be also raised in state court. So with these decisions starting to come out, and they really very narrowly interpreted this immunity provision, later in October, Health and Human Services issued an advisory opinion, which I've identified there, critical of the narrow interpretation and explicitly stating that it includes decisions to withhold countermeasures as a matter or prioritizing resources, meaning they're concerned that this federal law should have a broader scope, meaning if you decide not to employ countermeasures, that you're still protected in that decision. So all of that is to say that Pennsylvania, New Jersey, and New York state laws provide protection. In Pennsylvania, that's only limited to the executive order from the governor, but there are protections out there, and we need to kind of watch how the courts are going to rule. It is a pandemic. I would expect once these litigations start to move through the court system and get to higher appeals courts, that I do anticipate that that there would be a broader interpretation of the immunity, meaning that for your purposes, if somebody were to sue you for some COVID-19 related liability, that if you were in the healthcare sector, that you can expect reasonably that there would be a defense that you are immune from that. And once those precedents are established, those lawsuits would drop fairly quickly for purposes of infection and things such as that. As I said, the PrEP Act is likely to be reviewed. Sorry, that was PrEP Act, not the PrEP Act. And this is limited to care provided during public health emergency. And I think that's the most important takeaway, is that any liability or immunity from liability really is related to what goes on in this public health emergency. So I'm going to pause briefly there. I think I spoke mostly about liability. I'm next going to talk about risk mitigation measures that you can take. So I don't know if anyone has any questions or anything at this point.
Please enter your questions or comments into the chat box and we can ask them.
I just had a couple comments from notes that I wrote down until we get something in the chat. I represent an anesthesia practice, so we did directly see a downturn in elective procedures through the months of March through May, and thus far we haven't seen any yet for this wave. Hopeful that we don't. I had an interesting experience that I'm going through right now. I did have a couple worker comp claims that I put in for some of our clinical staff that had to get tested. I did call my worker comp provider ahead of time and to get guidance on how to proceed. And they told me to go ahead and put the claims in. Thus far, they were just tested and they were negative, so they immediately closed the claim. However, I did just receive my first positive physician in my group, and it was interesting because they came back at me and they said, now this is what I want to hear from you. In the state of Pennsylvania, they said that it's going to be an automatic denial, and the burden of proof is on the employee to prove that they got it from work. So that's what I'm going through now, is a learning experience. And my claim adjuster said, this is a learning experience for her also. And then the last thing I just wanted to say, because of my senioritis, I have to say it or I'll forget, is that when you were talking about the licensing in Pennsylvania, I have another physician who came to us from out of state, and he came to us in August, and he's still struggling to get he got a temporary Pennsylvania license, but he's still struggling to get his permanent Pennsylvania license because of the backlog with the COVID. Mm-hmm. So those two items, I just wanted to hear what you have to share.
Yeah, I think I would agree that generally the burden being on the employee to prove that they contracted a positive COVID test in the workplace. And again, I'm not a workers' comp attorney, but I do think that would be generally the position that the workers' comp carriers would take. I think, again, these are now starting to work their way through the courts. Probably going to have appeals taken and that ultimately resolved. But I do think that I think is consistent with what I understand, again, as a non-workers' comp attorney. So with that, why don't I know that we want to get to what some of the risk mitigation efforts, and I want to try to cover that fairly quickly given the time that we have. But you're already doing these. I'm almost certain of it. We talk about the triage. You're following, with triage meaning that you're going out and patients who are coming in are probably completing these forms and indicating, do they have a temperature? Have they traveled to certain states? These are things that are going on. You're following these guidances that you're getting, particularly with patient space and employee protection. You're adhering to the governor mitigation efforts. You're dealing with hours of operation. You're addressing staffing and the use of personal protection equipment. You're using electronic communication to communicate with and schedule patient visits. Some of you may be incorporating telehealth into your practices, depending on how you do that. Certain ones cannot, but certain ones can. Talked about pre-visit screening, limiting visitors, temperature readings upon arrival, and the scope of the patient procedures that you're performing. These are all ones that I'm telling you things that you're already incorporating into. And so I think all of those are to be recommended. And so starting this conversation, what is the likely standard of care during the public health emergency? And I think it's important to recognize that there's not a change with respect to non-COVID treatment, meaning that these are, you're not going to somehow get away with, if you will, committing normal malpractice and be able to argue, well, this is, COVID, we were overtaxed and things such as that. I don't think you need to, it shouldn't be approached that way. And I think that's something to recognize. But what it does is give you the confidence that if you are rendering services to patients with COVID, if there is an infection that occurs in the office, that you are hopefully going to be able to avail yourself of certain immunities from that. There's patient pre-visit screening to detect COVID-19 in compliance with mitigation efforts. That likely is going to be a standard of care. Therefore, if you have not done that, I would recommend that you implement that as a risk mitigation strategy. Same thing with temperature readings upon presentment, although that's so ubiquitous with healthcare offices, I just can't imagine anyone not doing it. But again, if you don't, then that might be failure to meet the standard of care, dealing with what we're dealing with here. Signage. Some of you have implemented signage, which I think you've gotten from professional associations. Again, that's something that would likely be something that you could argue, if you had to, that somebody assumed the risk of entering your space after reviewing the sign, which basically stated that, you need to do certain things, and that there's a risk of infection. Contact tracing, again, I think is going to be considered to be sort of a standard that your offices are going to have to implement. I know you have already, but not only for employees, but also for patients. We talk about patient liability. We'll flesh out in the courts what the scope of that immunity is, but it's always important to recognize that once the physician-patient relationship has been established, professional liability may ensue, and there's really no special exception to get around that. So that may determine your ability to take on new patients. If patients have become inactive and want to become active patients again, that may affect your decision as to whether or not, again, that you allow them to do so. I'm just going to touch on again the statute of limitations in Pennsylvania for medical malpractice claims is 2 years from the date of injury, with there being possible exceptions when injuries are discovered at a later date. But the other thing is, for those who are offices that deal with minor patients, they can bring medical malpractice actions 2 years after they turn 18. So again, for those in the pediatric field or dealing with pediatric patients, you need to realize that the exposure is greater there. So I'm going to talk briefly about revisiting patient consent forms as a risk mitigation strategy. Almost all healthcare providers have consent forms, which you ask patients to complete. The reason you do that is it protects you against risk of claims of battery or assault, which is what a lot of the patient claims are based upon. For in-person services rendered during this time, patient consent should be obtained. And again, many of you may have already done this, but in your forms, what you're going to want to have these patients sign before they come in to visit would be these items that I've listed here: a description of the reasonable efforts that you have taken to minimize the risk of exposure, but an express statement that not all risks can be eliminated, an acknowledgement and express assumption of the patient that he or she will be exposed to such risk, meaning he or she is assuming the risk by entering because she's acknowledging that there is a risk. The acknowledgement by the patient that he or she is not symptomatic and has not been exposed and has adhered to public mitigation efforts prior to the visit. An acknowledgement by the patient that he or she will follow safeguards, which you probably list, an acknowledgement by the patient that he or she will alert immediately if she is symptomatic. I recommend also to you to consult with your carriers. It sounded like consulting with a workers' comp carrier was done previously, but to consult with your liability carrier. Your professional associations also typically give good guidance in that regard, and obviously legal counsel can be consulted to kind of revisit that to try to again mitigate the risk of risk of liability. I'm going to pause here, but I have to say I'm looking at the time. It's 7:15. I want to give Dave enough time to give his presentation. So in that regard, maybe what we'll do is I'll cover the other mitigation strategies that we're talking about here, and then I'm going to turn it over to Dave, because I know you're going to want to hear what he has to say. So
Thanks, Peter.
yeah. Touching on this, we're now turning to relationships with your employees, and probably the number one risk of employer liability during this public health emergency is safeguarding the workplace. And if you've not done so already, it is recommended that you implement best practices. I can't go through those with you in a slide presentation, but again, these are things that many of you have already implemented, chief among them, which is to provide them with personal protection equipment, allow them to report if they are symptomatic, and allow them not to work for that period of time. These are available, again, from professional associations. We always like to recommend that you want to review and have input from Labor and Employment Council. But you also have them from the CDC guidelines. OSHA has also issued guidelines with respect to this. And, again, keys to mitigating these risks, screen employees, have them, make it clear to them that if they are symptomatic, they should not report to work. Again, things that you've already done. Equipping with PPE, training the employees, monitoring the employees, responding immediately or promptly, rather, to employee complaints. These are all things that mitigate or reduce the risk that you would be subject to an employee liability action. I also, also important to apply the rules to employees uniformly. You don't want to have a disparate treatment of different employees. That only increases the risk that they would make a claim and make it easier for them to prove. Contact tracing, again, things I think that you're already implementing. We're just briefly touching upon new COVID-19 risks. You are starting to see OSHA complaints from employees. We touched again on workers' compensation claims. I learned from Dave, particularly, I think it was New York or New Jersey, that whistleblower-related actions related to failure to implement guidance from state agencies are on the rise, meaning people who are employees are reporting what you're not doing, and that's considered to be whistleblower action. Discrimination claims, and ultimately personal injury and wrongful death, although obviously in certain settings, I think the majority of which apply to you, it's unlikely that would really be a predominant risk. Other risks here, furloughs, layoffs, and returns to work. These are all things that I think you may be contemplating, if not already facing. How those are handled determine the risk level. There is a Department of Labor Families First Coronavirus Response Act, which provides certain guidelines to employers. That's something that I would recommend. And again, reasonable accommodation, which is, I'm sure you're familiar with, if somebody has a disability that you need to, as an employer, make reasonable accommodations to them. These are risks also that can't be ignored simply because it's a public health emergency. So again, these are some of the risk mitigation sort of strategies that we're recommending. Turning then to provider relationships, and it's really created issues, sources of referrals, as well as those to whom your office refers patients are encountering the same difficulties. These are, again, we're seeing things that I talked about before in terms of provider relief fund, things that you may want to, if you have not already done so, is consider the consolidation and whether or not that's something that needs to be considered as part of a long-term survival strategy for your business. There are also long-term expansion opportunities. And by that, I mean, over time, if you are implementing telehealth, for example, that's a resource and a field that's going to continue to grow. So if you're able to incorporate that into the practice successfully, that is clearly a revenue source that would allow you to expand. And then also when we talk about worst case scenarios, we talk about the possibility of bankruptcy and insolvency. I will tell you that I think that where I see that emerging is in the first half of 2021 as a serious consideration for people. I think from what I've understood, with things somewhat picking up in terms of business and having that provider relief fund, that may have allowed that sort of bridge, if you will. But we're going to see that. I'm going to very briefly, and I include a lot of slides on this, touch on certain guidance that's been issued that equate to temporary waivers of certain fraud and abuse related provisions, specifically the federal anti-kickback statute and the Stark self-referral law. I'm going to apologize by going through here, but these are really descriptions of what those are. And I think you may be aware of it, but just briefly, the anti-kickback statute makes it a crime for a provider who is reimbursed by the Medicare or Medicaid programs to offer anything of value in exchange for referral of such business. There are exceptions to that. As with Stark, there is a self-referral prohibition, meaning if you're a physician, you can't refer patients to entities with which you have a financial interest. However, like with the anti-kickback statute, there are specific exceptions to that. What the Medicare agency and the OIG have stated is that for this period during the public health emergency, there is going to be a recognition that some of these requirements are relaxed. They don't necessarily get into or have gotten into detail in terms of what those are. But I will tell you that generally, for those of you who have kind of structured your operations to meet these things, to make sure that you're not giving anything of value, that particularly if you're operating in an environment to try to increase access to care, that it's unlikely that you would be facing either prosecution or more likely civil liability related to violations. And that's important to recognize because, again, a lot of you are looking for ways to develop these relationships with the provider. You don't need to be concerned about as much of violating any of these two acts, or really those types of initiatives being viewed as being fraud or abuse on the government's end. Really, the fraud and abuse actions that we've seen are really directed to people who are taking advantage of the COVID and the funding. So again, operating at warp speed, as the president says. I want to just touch on the last item here, and that's vendor and landlord relationships, and those with whom your office contracts for supplies and services, vendors. You're going to see a possible breach claims. That's not only with people who provide you with services, but also those for whom you make payment. So you need to realize that those claims are likely to increase. We talked about act of God provisions there and those interpretations. Right now, what we're seeing is that pandemics, unless they are specifically referenced in a contract, are unlikely to be viewed as an act of God, which would allow you to get out of a contract. So hence our recommendations, you want to review your relationships with vendors. And if you are on either side, either your side or the vendor side, close to being in default to begin negotiations to amend those contracts. If default has happened and you are the non-defaulting party, you want to send written notice to the defaulting party of the default. And then obviously if you're getting notice of any potential claims, you're going to want to put your insurance carriers on notice of those. From leased property standpoint, notices, as I said, are coming from landlords to commercial tenants and from tenants to landlords, dealing with things such as temporary office closures or rent abatement. Again, to reiterate, it's unlikely, unless they're expressly mentioned in a lease, that a pandemic would be considered an act of God and allowed to get out of the lease or stop complying with the lease. So again, recommendations here to review the lease terms. If you're in or close to a default, to begin negotiations for an amendment of the lease. If the other side has defaulted, to send a written notice of default, and again, to put your carrier on notice of any potential claims. So with that and those sort of mitigation strategies, which we'll hopefully take questions on a little later on, I'm going to turn it over now to David.
Thanks, Peter. Well, first, I had a little bit of an issue with my audio at the very beginning, so can someone just confirm that they can hear me?
I can hear you, David, now.
Okay, great. So I'm doing this off my phone, which I'm not terribly used to, but I can see the chat in the bottom. I was hoping, like as Peter said before, that we could make this sort of an open discussion. So if while I'm discussing telehealth and sort of the liability that comes into play with telehealth, if anybody has any questions, please feel free to log that into the chat, because I can see it, and I can certainly obviously respond to it while we do that. We're talking about liability today, and of course, when we talk about liability, when it comes to the provision of telehealth, we are thinking both not only on the malpractice side, right? Are we properly treating patients in accordance with standard of care, but also when it comes liability when it comes to reimbursements from insurance companies. I think obviously there was a lot of confusion at the beginning on the onset of COVID. Are insurance companies going to pay us for what we're about to do here? We haven't done this before, so how do we properly bill? And there's a huge liability there as well, because we all know that insurance companies and payors are sort of in the business of, or not in the business of, paying out, and will try their best very often to try to recoup money through audits, etc. So we always want to, at the beginning of a new venture, and document correctly and make sure that we do everything that the payer wants in order to get paid. So we'll talk about that as well. A lot of what telehealth involves was touched upon by Peter, so I'm going to try my best not to overlap here. And considering the time, I know we do also want some time for questions back and forth, so I'm going to try to get through this fairly quickly. So I represent a lot of solo practitioners and smaller to mid-sized groups. Very often, the doctors and the practitioners are extremely busy, of course, and the people that I speak to when I'm dealing with and trying to handle and represent the practice in connection with whatever matter they have are the office managers. So I sort of hold office managers sort of near and dear to my heart. But through my communications with them, I get a good sense as to what the ground level issues are. So it gives me sort of a unique perspective on what not only that particular practice is dealing with, but assuming they're just like everybody else, knowing what most of the practices around in the area are dealing with as well. So at the onset of COVID, I can tell you that, and I'm sure Peter agrees, the inquiries that we got were numerous, and a lot of the times we could not answer because we just didn't know the answer to the question. And so it was sort of a learning process for everyone as at the onset. So how did we get here? I mean, we have to talk first about what the world was like pre-COVID, if anybody can remember. When it came to telehealth, I felt that relatively few providers actually utilized telehealth. There was a little bit of confusion about it, skepticism about it. How do I do it? How do I set up my practice to do it? Am I going to get paid for it? Was always a concern. I think a lot of people were worried about their liability how could I possibly properly treat a patient by watching them on video as opposed to seeing them on person. I think practitioners in general want to be hands-on and be able to touch the patient to know exactly what's happening and to study their responses to some of the questions that they might ask. So there's a lot of hesitation, even pre-COVID, when it came to that. Will the patients want it? Do patients feel comfortable, or do they have an expectation that they're going to come into an office and sit for a little while in the waiting room and then go into the main room and wait for the practitioner to come in? I mean, that's part of what everybody believes and is used to the healthcare experience to be like. Now, I think patients, or the worry was, will patients comply? And I think we all know now that generally there is a good subsection of our patient population which is non-compliant to begin with. But now, are they going to listen to and adhere to the rules that come into play when it comes to telehealth? So one of the biggest concerns, of course, was whether or not the equipment and the platform that would have necessarily been used pre-COVID for telehealth services was secure, and whether or not it was something that would have been in accordance with whatever the guidelines by CMS and otherwise would be. And so for a large part, I believe that practitioners felt it just wasn't worth their time and effort to get into it. And I think people heard also some disaster stories about it as well. Like, for example, I was involved in a case where pre-COVID, I guess in the early days of people trying to utilize telehealth, one particular client of ours, was trying their best to comply and perform services on behalf of their patients. And as it turns out, their system wasn't. Well, the system was utilized through the EHR system that they had in order to perform those services, and it wasn't secure. It wasn't secure enough, and there was a system breach. And of course, as everybody knows, dealing with the Office of Civil Rights and with the when it comes to HIPAA and high-tech violations and breaches, the penalties for violations like that can be enormous. And this was a huge problem for this one particular provider. So everybody talks. Those stories must have gotten around. And so from what I recall, pre-COVID, telehealth was something of a mystery to people. And, only certain safe, not safe, but courageous practitioners would venture out to try it out. But of course, at the onset of COVID, I guess in and around the earlier this year, in March or late February, suddenly not only was telehealth something somewhat of a mystery, it suddenly became encouraged as something that everybody should do for many different reasons, some of which are obvious. And to their credit, the government really set forth rules and regulations, or at least took away regulations, which made that possible and made that easier for practitioners to do. So it became an immediate learning curve for everybody in order to implement the appropriate way to do this. And I'm sorry, please let us know if you have a topic we can. So what did the government do? They temporarily eased some regulations and regulations that incorporated or at least previously prohibited certain specialties from telehealth, and now suddenly they could get into the market that way and treat patients. Some payors, HMOs, and so forth were now mandated to reimburse and relax their own rules, because that was always a concern as well. Now, there were now many more options, considering different specialties, to get into the telehealth space, whereas previously you could not. It became very, very important to know what the Medicare and Medicaid guidelines are. And I always encourage clients and people involved in the healthcare space to go on the OIG and the OMIG websites, sign up for their mailing lists, get in obviously touch with your specialty societies, and also talk to different experts and groups like PAHCOM. These are the people that have the information that will help you implement the type of practice that you want, especially in this context, telehealth services. So those guidelines are going to be very important. So at the very beginning, people were obviously wondering, what are the guidelines? How do we get this accomplished? Also, just as importantly, know what the private payor rules are. And so, like I said before, these private commercial companies, these insurance companies, they are generally loath to pay for new types of services. They will impose their own sort of regulations. Of course, they have to comport with federal Medicare regulations for the most part, but they can also make up their own to be more protective. And a lot of times, people will not, and practitioners will not know them. So it's important to know what those are. I mean, I could recall at the very onset of the crisis when my clients were gearing up and setting up their practices for telehealth. A lot of times we would say, we have a question about whether or not a particular HMO will pay for this service or how they want to code it. Let's just call them. I mean, I know it might be very difficult to get a hold of them sometimes, but sometimes just going straight to the source and asking them what they need in order for these services to be paid, in order to prevent a future overpayment or audit. There's nothing that would prevent us from doing that, and I would encourage, and I have encouraged practitioners to do that. Now, of course, practitioners can always lean on their attorneys as well. Not to make this a pitch for healthcare attorneys, but we are there for this purpose. And same thing goes for coders. The question is, how do we code these services, these telehealth services? Now, you can go to the NGS FAQ. NGS is just a contractor for Medicare, and you can simply Google NGS telehealth billing FAQ, and you'll see the different codes that will necessarily be required for these types of telehealth services. So it's important to know those if you're not going to employ a coder, but I would strongly encourage, like we always do, for practices, especially smaller practices, to retain coders in order to review and also educate. And so very often early on the onset of COVID, people or practices who had no prior experience with coders, even though their healthcare attorneys constantly tell them to associate themselves with them, were suddenly retaining coders to obviously educate themselves as to how to bill for and code for the services that they were now going to be providing via telehealth. Now, one of the toughest things I think that people and practitioners were worried about was how to maintain the same sort of standard that they would have normally maintained with patients in person, as opposed to over some sort of platform. And I definitely sympathize with that fear. Take, for example, an example that I could think of. If you were a practitioner or a provider and you are doing a well visit remotely, and you're watching a patient describe what they think is just sort of normal cold symptoms. Now, that already brings into play whether or not they have some sort of COVID-related issue, right? Especially at the onset, we didn't really know what the real sort of symptomology on a patient saying they have chest pains, right? So I've had that question come to me. So a lot of times I think we always try our best to not do this, but we practice defensive medicine, and there were immediate calls, go straight to the emergency room, right? And that was also another concern. The emergency rooms were going to be filled up with COVID patients. Did we want to go and send our patients there? But with chest pains, how can you not? So it's that kind of liability fear that people were scared of. And like Peter touched upon before, that's why thankfully the government did provide some immunity. I think that a lot of the people on the plaintiffs bar, at least people who sue and create these lawsuits against practitioners for medical malpractice, would have a hard time not bringing cases in that type of scenario. So I understand the fear, and that was certainly something that I heard a lot from clients of ours. Now, the rule is always the same for all of our clients and all the people that we do talks for. Probably the main defense and the most important defense to any sort of feared liability is going to be your documentation. And we'll talk a little bit more about what that means in the telehealth realm. But documentation rings true for telehealth services just as much, if not even more, when it comes to in-person encounters. And so documentation will always be the saving grace and will be your best defense. And lastly, when it comes to suddenly being able to and now suddenly having to incorporate telehealth services, we have to always make sure that the the practice has in place written policies and procedures in the event that there's some sort of failed transmission during the course of that encounter. And we all know that practices are charged with having many different types of written protocols in their practices and in their office. This is just another one. So if you don't have that, and or you have questions about that, that is certainly something that's essential. So a written protocol in the event of, at the very least, in the event of a failed transmission. And what I mean by failed transmission is, what if you are handling or going through or a particular telehealth service in real time, and for whatever reason the screen blanks out or the connection goes out. Well, that's still a patient. It's still an active patient. You have to do something about it. So we'll talk a little bit about more about what types of safeguards there could be in those policies and procedures in that event. But at the very least, have a different means of communicating with that patient in the event that happens. So have their phone number, have their the information for their next of kin and their close, their family members, in other words. So in the event that happens, you can reach out to whoever it needs to be to continue that process, so that they don't have, there's no discontinuity in their care. So why is telehealth important? I mean, for obvious reasons, but we're essentially meeting patients where they are, as opposed to having them come into our office. And actually, when you look back on it now, I know it was born out of necessity, but it seems kind of silly that we weren't doing this more often and that the regulations were not eased a long time ago, because there are a lot of different scenarios where it would have been extremely helpful and much more comfortable for patients. Okay, I can tell you, and not to make it personal, but I see a doctor regularly every 3 months just to get a prescription for very benign and common high blood pressure medication. Do I have to go there every time to the doctor? I mean, the doctor, is a very nice person, and I'm sure she likes seeing me too. But we do that over telehealth now since the onset of COVID, and I hope that continues. I know we're getting a second wave here, but I hope that those kinds of scenarios and arrangements continue, because it allows for more efficient healthcare, I think, in that practice. Now, what we have found also, and this is what practitioners are reporting to me, is that surprisingly, patients are actually appreciating the telehealth services, whereas before the fear was, well, will patients comply and like this, right? It's actually the converse. Patients appreciate it, and they are willing to forgive some of the glitches that might come into play, where, as before I had problems with my audio, or if it's you hear a little static, or if it's there's a little bit of lag. I think from what I'm hearing, patients are just appreciative of the fact that they're safe at home and not having to travel somewhere, and that they have the mechanism to see a doctor when they can for more minor symptomology or complaints. Okay, and another example as to why telehealth is important is PPE. Everybody knows that at the onset and continuing, PPE was at a seeming shortage. It was hard to come by, and obviously it makes it much more easier if patients are not coming into the practice to not have to deal with PPE in the office and getting that situated, purchased, found, located, whatever the case may be. Also, for the safety of patients and their families, especially if you have minor patients who are going to come in with their parents, you have much less of an interaction between people who could obviously infect each other, and that is something that is vitally important. And I know that people don't want to necessarily talk about this, but it is true. We also want to maintain practice revenue. Now, everybody was scared at the beginning. We are in the healthcare space, and so there was a sense as COVID is a virus, and that should make healthcare become more necessary and needed. But there were many specialties I touched upon before which had very difficult times, especially when it came to issues with respect to locating PPE and some of the more maybe elective types of encounters or procedures that would have necessarily brought in these encounters. So maintaining that practice revenue was important. The government did a lot in order to provide certain disaster loan assistance, et cetera. But I think that the telehealth services really went a long way in expanding that revenue stream to the benefit of practitioners. One of the things that the government did in expanding or taking away regulations, they expanded the technology that could be utilized in order to perform these telehealth services. So they incorporated smartphone technology. There was a extremely important regulation or promise by the Office of Civil Rights. They would not impose penalties against practitioners for what they call good faith violations of HIPAA and high-tech. Now, I'm not telling you anything you don't already know. The penalties that come into play for breaches and violations of those particular statutes are enormous. They're practice ending, or they can be. So that promise that they would not impose penalties or commence investigations due to good faith violations was important, and those platforms that were going to be expanded into the sorts of platforms that we're all sort of getting used to, right? The FaceTime Messenger, Google Hangout, Skype, those types of things that people were sort of getting used to using on an everyday basis. We can now use those to implement telehealth services, and that was important because one of the main concerns was whether or not patients could figure this out, right? Especially in underserved areas where it became incumbent upon us and the practitioners to explain to them and educate them how to do that. Telling them that they can get on a platform or an app on their smartphone that they were probably using every day anyway was much more was very important. We just have to make sure, obviously, that those platforms are encrypted. For the most part, they are by default. But if not, we have to make sure that those encryption methods are enabled as well. And part of that is, again, even during the telehealth service, explaining to the patient what's happening and that the encounter is encrypted and safe, et cetera. And we'll go in a little bit about what that consent should look like and those explanations should look like for patients. We don't need to ask that, and CMS actually put out a guideline specifically asking that practitioners not use what are called public-facing apps like TikTok. And I have to admit, I guess I'm aging myself a little bit. I'm not entirely sure what TikTok is. I know it's something that younger people use. I do have an anecdotal story about TikTok being sort of a very dangerous app to utilize in a healthcare setting. I had a client whose daughter was into making TikTok videos and, for whatever reason wanted to post a video saying, hey, look at me. I'm sort of helping out my father in this busy medical practice and sort of did a screenshot or a video of her surrounding area. And of course, in that video was, hundreds of patient records and some patient records, which you could actually read the names of the patients there. And so that became an issue. So that's just a small example as to why we're only going to use sort of the encrypted and the safest types of platforms, but also still be cognizant of the fact that we have to deal with patient privacy and those types of issues. Okay. So trying to go this through a little faster because we're getting up on 8 o'clock here, but the immunity provisions that Peter had spoken about before are still, like he said, apply to telehealth services. So in furtherance of the provision of healthcare for the treatment and the diagnosis of COVID, you enjoy an immunity from liability there. And different states have different standards. They might deviate from what the federal standard is, which is, and the standards being sort of high. Okay, willful misconduct, gross negligence, all of those standards that you hear about are extremely high. So you'd have to find, like Peter used the word before, wanton deviation from the standard of medical care. You'd have to find that type of scenario in order to assess or assert liability. I know the plaintiff's bar will try regardless. I'm sure that's coming, like Peter had said as well. But I think that there's some pretty good protections there. And so we're hoping that those immunity provisions will hold up. So just to give you a little bit of an example of what I think the best practices have been from what I've seen practitioners do and what I've advised and us as a firm have advised practitioners to do. We have to obviously remain within the scope of practice. Just because we are suddenly providing healthcare services through telehealth doesn't mean that we can deviate outside from that. So if you feel that you are dealing with a patient concern during the encounter that is something outside your scope, that's something that you need to advise the patient about and have them seek sort of consultation or seek healthcare elsewhere. If it's an emergent issue, also, like you always do, counsel the patient to go to the nearest emergency room. Now, the consent, a written consent has to be documented. Okay, and this is essential, and consents need to be documented for most diagnostic procedures for in-person services, and we have to think of it just like that. We have to have a conversation with patients about the role of telehealth and how what rights they have and obligations that the practitioner has. Now, I can tell you that I have a client who did not put a consent in their records for their telehealth services, and that would have just been a simple acknowledgement by the patient that they consent to the service being provided by telehealth. It's kind of a counterintuitive. The patient obviously knows they're dealing with a particular encounter, not in person, but via some sort of platform. But that documentation needs to still be there. And this particular client has been audited by an insurance company. And of course, like I said before, I'm not a big fan of insurance companies and payors. They're taking it upon on themselves to exploit that and try to recoup payment for or reimbursements for those types of encounters, which is not fair, and we're fighting that, of course. The consent needs to indicate that the patient has a right to refuse a telehealth service, and then must be provided alternatives in that event. And that also alerted to the dangers of an in-person visit. So if over the course of their telehealth service, a patient says, you know what, I'm not comfortable with this anymore, I definitely want to see you face-to-face, or I want to see somebody face-to-face, they have to be provided that right, and obviously an alternative. But conversely, and I think this is there to try to prevent patients from in-person encounters, which might spread the virus, they must also be told of the dangers of those in-person visits. The consent also needs to just indicate in a very short way the role of the practitioner at the distant site, if there is a distant site, and also made aware of the location of a distant site. So a lot of times patients can either be performing or involved in that telehealth service at some other site, like a clinic or some sort of hospital setting, or they might be at home, which creates a whole other issue. Now, I think everybody, in case you don't know, if there is a distant site in a facility, there's a charge for that, and there's a code for that, and that's something important to know. But if the patient is at home, there's no distant site charge for that. You need to definitely document whether or not the encounter was via telephone or whether it was a true telehealth encounter utilizing an audio-visual platform. And again, insurance companies will take a look at that, and if it does not indicate that, seems silly, but they will obviously exploit that to audit and give clients and practitioners problems. Indicate in the record what platform is being used and the amount of time. Now, time is a very important factor because there are many codes and many bills that go out on a time basis, and with the convenience and safety of telehealth services and those types of platforms also comes with it, and the time that was actually allotted to that encounter. So whereas before, if someone were to question, well, did this encounter really take 45 minutes? Now we have a record of that through whatever system that you've used, and that would be, I know it to be, a discoverable event. So it's very important. I can just give you an example. I do have a particular client who is a mental health professional, and there's a huge difference, not huge, but there is a difference between the reimbursements between a 45-minute session and a 60-minute session. And this particular practice, as a matter of course, utilizes 60-minute or bills for 60-minute encounters. And the question has become whether or not those services really lasted for the 60 minutes. And the fight that we're having now is whether or not we are going to do an audit of the system in order to determine whether or not that is the case. So keep that in mind. It's something that can be a double-edged sword there. Okay, so how were practitioners actually setting these situations up? I'm going to go really fast here. They were, I think the best way to do it, and the best practices that I've seen, are creating what are called virtual walk-in hours. And what that means is we basically have a set time for when, and set a certain set group of practitioners in the practice which will deal with the telehealth services. You might want to utilize maybe those practitioners in your practice who might be at risk themselves to be performing those telehealth services, and keep maybe the people and the providers who are outside of that group to utilizing or seeing patients in person. Because you have to understand, patients, although there is a general sense out there that they should be keeping socially distant and being careful, there are patients who, when they want to see the doctor, will just drive over, and that happened plenty of times. I've had a client who was not set up properly, and sometimes you just can't be, given the amount of PPE you have and the amount of room you have in your waiting room, in order to keep people as socially distant as possible. So what this at the onset, what this practitioner was doing was, before they had the proper signage up and warnings on their website, and et cetera, they were actually seeing patients in their cars. So when patients would come in, they would essentially put a practitioner or a provider in like sort of a hazmat suit and come out and have a sort of encounter in the patient's car, if they didn't want them to come into the practice. So we should set up a system as best as possible to make sure that patients are not coming in sort of walk in person, and set up a sort of hybrid system where we have those telehealth services available for everybody. And a lot of this comes down to educating patients. And so that will become incumbent upon the practices to make sure they tell their patients, either through their portal, mass emails, social media, on their website, that this is how the practice is going to run from now on for obviously safety reasons, and also signage at the actual practice so that patients just don't walk in is going to be important as well. So educating patients is essential. Educating yourself, like I said before, learning the codes and how to properly bill for these services is essential. And all I would do is really try my best to warn and to emphasize that we should maintain our standards when performing a telehealth service the same as we would for an in-person encounter. I mean, it can be pretty silly, but I've had a couple of inquiries and one particular complaint made against a physician who was performing a telehealth service and made a comment, what we would consider a pretty benign comment, about something in the background that they were seeing in the patient's house. Now, patients are fickle, and they are sometimes very mysterious to practitioners. And this particular patient, for whatever reason, had a problem with that and actually complained of it, and didn't really become that much of an issue, but it's something that's preventable. If we keep the environment sterile like we do for in-person encounters, it sounds kind of silly, but we'll do the same thing, keep to those same standards for telehealth services as well. Now, just recently, like literally within the past several days, we have the physician fee schedule final rule, which was implemented by the current administration, which locked in a number of these changes and these regulatory changes and made them permanent, which I think is definitely a step in the right direction, because I would personally like to see that these types of telehealth services continue even after we finally get back to normal, how we used to be. And that this particular final rule called for significantly increased reimbursements for what are called evaluation and management codes. That's at the expense of specialty practices, and I think that's was though really important for general practices who were trying to stem their declining revenues, and also they were also seeing some sort of increased expenses as well, and so that was there intentionally to make up for that. And there are also going to be some certain expansions or making permanent certain expansions of certain specialties that can utilize telehealth, which I think is welcome as well. So those are the types of best practices that I've seen in the telehealth setting. We only have a couple minutes to 8, and I know that we wanted to have a little bit of a discussion regarding Q&A. So I just wanted to just very quickly one additional comment on what I think is going to be the next sort of emerging legal implication in all of this, which is whether or not they're going to make the current not current, but the future vaccinations mandatory, and that is obviously a huge issue because we have a politicized environment anyway, and there are many people who you might have heard who have said that they will refuse to take a vaccine no matter what, and you've heard some people on the other side of the aisle saying that of course they would, and they should be mandated everywhere. So there's sort of a fight between what one side thinks is for the greater good and what the other side thinks is going to be in furtherance of your individual liberties. Both extremely important, obviously. I just think it's something to think about. Now, there is a legal precedent for mandating vaccines back to a Supreme Court case in 1905, which is called Jacobson versus Massachusetts, which mandated the smallpox vaccine. Interestingly enough, the fine for that, or the penalty for refusing the smallpox vaccine back then, was a $5 fine. So, I couldn't imagine what that would mean for these days if they were trying to make it mandatory. If I have to guess, I would say that it will not be made mandatory, but it is something to think about because I believe that it will be made mandatory for certain segments of the population or of the employment population. And the reason why I'm bringing this up is because I truly do believe that the healthcare setting would be a sector that would be obviously ripe for that type of analysis, that there would need to be some sort of mandatory vaccination for healthcare practitioners. That being said, now we all know that there's even, at least in New York, where I practice primarily, there is a mandate for healthcare practitioners to receive the flu vaccine, and that's fought by many people as well. So, I guess time will tell how that's going to play out, but I do think it's important enough for us to keep that in mind. We're going to have employees in our practices, which if they do mandate a healthcare sector mandated vaccine, you're going to have to deal with some employees who might refuse it, and so we have to think about what we're going to do there. So it's 8:01, and I know that we you might want to have a little bit of Q&A here, but I thank you for your time, and please, if you have any questions, please let me know. Otherwise, you can certainly email Peter and I at any time. Thank you.
Thank you, David.
Sure.
I'm going to let people enter comments or questions in the chat. I do want to give you the same courtesy, David, as I gave Peter, and read your introduction. David is also a member at the law firm Norris McLaughlin, along with Peter. He devotes his practice in the areas of healthcare and litigation. David's practice focuses on defending healthcare professionals in connection with disciplinary and regulatory actions before federal and state agencies, private and government payer audits, civil and criminal fraud investigations, hospital and privileges disputes, and general health care litigation in both the federal and state courts. Thank you both for your time and effort tonight. I'll give it another minute or two to see if we get any comments or questions. If you want, I'm going to advance your slide because that's where we have your names and information. But again, this presentation was recorded and it will be available in the PAHCOM website library. It is worth 2 CEUs. The index number will be emailed to you shortly after the presentation. Brenda, do you have any last minute comments or anything?
No, I appreciated the updates on the telehealth and the different methods of it, because I do know we toyed with it in a little bit in the beginning. We ultimately did not have to use it, but it was interesting to find that we could even FaceTime. That was an option. If the patient, we had to find out from the patient ahead of time what mode they had, because not all patients have even computers. available. So it is interesting to hear about the different methods out there that were being used. And I agree with David that hopefully this will continue, because it is a good way to maybe get more patients to comply with seeing their physicians if they can't even get there physically with transportation.
Yeah, it's very convenient. All right. Our January meeting will be virtual as well. Wednesday, January 20th, James Plum, our billing manager at Kidney Care Specialists, Valley Kidney Division, will be speaking on coding in 2021, following a 15-minute Zoom webinar. So there'll be 2 separate logins for that evening. The webinar jam is open to everyone in PAHCOM, and then we'll be sending out a Zoom invite to only the Lehigh Valley chapter members to log in for our just chapter meeting. And I'm hoping that in 2021 we can schedule something with both David and Peter in person.
Yes.
To do something.
Be happy to.
All right, doesn't look like we have any more questions or any comments. I want to say happy holidays to everyone, and thank you both again, David and Peter, for your time. This was very informative and some good suggestions for everyone, and I hope everyone has a good night.
Thank you.
Thank you, you too.
Thank you.
Yeah.